from the Willwriters Association once more. In lessons 2 and 3, you will recall, we identified the 3 different types of English-speaking person, which we call groups A, B and C, who become affected for all time hereafter by the EU Brussels IV legislation, wholly effective throughout Europe from 17th of August 2015. For the avoidance of doubt, this statement is true even if the UK were to leave the EU, and it does also apply to people from other English-speaking countries from around the world, such as Canadians, many of whom own property in France, and Americans who own property in Spain and Italy and so on. Again, for the avoidance of doubt, if it were, however, that a country such as Greece was to leave the EU, then Brussels IV would no longer apply to anyone owning in that country unless that country voluntarily retained the main principles of the legislation on its books, which would be very likely. Because, well, what are those main principles? They are that when someone owns property in another country and lives there habitually, such as an Englishman in Greece, who then dies, still living habitually in Greece, then those people should be able to have the choice of 1. Making a pure natural will of that country, according in this case to Greek law. However, it's recognised that that might present cultural problems. Or 2, a will made in Greece, the Greek way, so that it's done locally, but based on what is legal in their own country and culture. Or finally, 3, that a will can be made in their own country, nationality, dealing with their property in Greece, which should become capable of being a valid instrument in Greece. So there are the 3 options that Europe believes should exist for any human being owning property within the EU, no matter where they live in the world. There's no real reason why Greece, which has adopted Brussels IV, should not keep it on its statute book if they left the EU. Options 1 and 3 have been options for a long time and is what everybody has done for many, many years. And the new option 2, which by then is already in place and operating, meaning Greek testaments written under BR4, will be working fine. So why stop it? Now let's move on to something different, which is the subject of opposites. The deeper that you move into this course, and if you choose to do it also, the succession taxes and tax saving course that follows it, called Roost, the more you come to realise that almost everything in Europe, especially the Mediterranean part of Europe, is done differently and very often in exactly the opposite way than in the English-speaking world, and in particular the British Isles. The most obvious example is that Europeans drive on the other side of the road. Another illustration, which is not quite so obvious, but in a way much more typical of the time of problem we shall be encountering as we move down this journey, is that whereas an English-speaking person wanting to write down the sum of money £1,234.56 will write £1, 2, 3, 4, 56. His or her European counterpart, however, wanting to write €1,234 and 56 centimes, will write €1.234, 56. It is as if Napoleon looked over the sea and dictated that whatever the English did, he would do the opposite. Now, we are going to raise 3 much more serious and important examples of this with you in this lesson, which looks closely at that group of your past clients, your existing clients and their children and possibly grandchildren who live in the British Isles and who have some form of interest in a property in the EU. The purpose of this lesson is to deal completely with that Group A of people. To be in Group A, they must habitually live in the British Isles, but own property somewhere in Europe. We must provide you, and in turn them, your clients and prospects, with the answer to the following key questions from a clear understanding of the relevant key facts. As a note on that point, there is an entire lesson, a standalone lesson covering key facts, which is lesson 20, which you can listen to at any time through the course, beginning, middle, towards the end, after the end, go back to it later, etc. Those key questions, those 4 key questions at this stage are: what kind of will have I, or has my client, got today covering their property abroad, overseas? Question 2. Is it valid from the 17th of August 2015 onwards? Will it still be valid? If it is valid, nevertheless, is it the best possible option? And if the answers to 2 and 3 is no, it's either not valid or it's still valid but it may not be the best option, then what kind of will do I or they now need? Now, before arriving at those answers, however, there are 3 relevant pieces of information that must become ingested by you, turned into absolute knowledge. You must be able to deliver that information, that advice and those solutions with complete authority. Before we tackle those questions and their answers, let's however just make 3 things clear and in profile. The first relates to the general phrase wills and testaments. The history of wills is a long one. Both Julius Caesar and Cleopatra had a will, and all of the Romans of their day and Egyptians. They were not entirely as they are today, and there is a certain amount of mist and fog surrounding the detail of wills from those times. What is absolutely certain is that any Roman citizen was required to write a will if he or she did not have descendants who would then automatically become beneficiaries of their estate. It was therefore the Romans who brought the wills that we know today to Europe and the British Isles, though in something of a raw state. Before 1837 it was all a bit shambolic. It was different in different parts of the country, and there would generally be required to be 2 documents: a testament involving the transfer of any fixed property assets owned by an individual, and a will involving the transfer of chattels, movable property, money, bonds, etc. following their death. Somehow or other, in the 2,000-year travel of time between the Romans and 1837, there were places and lawyers who got those words around the wrong way, so it's not as clear as glass. That confusion became swept away by the 1837 Wills Act of England. It's interesting to reflect that the Act passed through Parliament at a time when everyone rode around on horses, and the only way of documenting any new law was to write it by hand, longhand, on a scroll. Only one copy. There could only be one copy. As came to be the position with wills. There could only be one copy. You couldn't guarantee to be able to write it for a second time with the same level of accuracy. That scroll, the 1837 Wills Act, still exists exactly in that form today and is stored beneath the House of Commons along with goodness knows how many tens of thousands of other Acts of Parliament. Acts of Parliament in those days were very short, and understandably so, and they were a very long way away from the type of Acts of Parliament that are passed today, which are very long. The brevity and the simplicity of the 1837 Wills Act, however, has meant that it has lived virtually unaltered until this day. And because of that, it is slightly obscure. There have been one or two alterations and replacement acts officially, but they broadly embrace all of the original phraseology. Now, that phraseology is very out of style today with the way that the law is written down and acts of Parliament are written down. It's the age of the 1837 Wills Act that actually makes it very easy for solicitors and others who are used to the way that the law thinks today and is written today to make wrongful assumptions about the rules of wills. However, that's an aside that we aren't dealing with in this course today. The first piece of information you require to know is that in the Napoleonic countries, they have testaments, but they don't have wills. The ownership of personal property in Europe passes through other sections of the civil code that each country has, and generally not through the notarized testament that it is open to a person from France, Spain, Portugal, etc. to make. However, because all of these Napoleonic Code European countries have a system of forced or obligatory heirs, where their assets, property, must pass to their children, the vast majority of the population simply does not write a will or write a testament. Passing their assets and property to be divided between their children comes as second nature to them. This came about in order that the small villages and towns scattered throughout Europe would not have to support the children of a deceased man or woman simply because they had chosen to give their money to a friend or a lover or some good cause. If any form of will is written, it is a testament, written for the purpose of giving some small portion of the estate that is allowed in law to someone other than their blood children or adopted children. In Spain, which we are using as our default example, if there is no testament at the notary office, then the whole immovable estate of the deceased is divided equally between the children of the deceased. This is the natural state of affairs. If a testament is written, which is notarized, then up to 1/3 of the property belonging to a deceased person can be given to someone else other than his or her children. Their 2/3, the remainder, is then divided under a formula between the children. We will deal with that in a later lesson. In that situation, what the French, Portuguese or Spanish man or woman is writing is a testament in front of a notary, which is a public document then, which is kept by the notary forever. That testament deed, which in Spain is called an escritura, meaning deed, then is numbered with a unique document number. It's printed on pages each that have their own number that are allocated to notaries. It is sealed and bound into huge volumes in document number order that each notary accumulates of all of the documents they notarize. So every notary has huge storage areas to keep these vast volumes, about a foot thick, of everything they've notarized in numeric order. Since the day of the photocopier and computer, it has been possible for people to obtain a simple copy of the document before it was signed, and in Spain that's called a copia simple, but it isn't signed and it isn't a photocopy of the signed document. And so, when you are talking about the document that in the United Kingdom, the Republic of Ireland, Canada and America we all call a will, being a short form of last will and testament, in Europe they will only refer to that document as a testament, testamento in Spain. In a future lesson relating to specific countries, you will learn how the civil code deals with the personal movable property, insurance, bank account, etc., of each individual inside a marriage, or less usually in the case of an adult if unmarried. You'll also learn in those same lessons about the intestacy rules in each of the countries in the EU, where the English-speaking people from the British Isles are inclined to buy property. In summary, as regards this 180-degree difference between ourselves and the EU countries, what English-speaking people refer to as a last will and testament, which embraces their guitars, their cars, their paintings, their chattels, as well as their land and property, in Napoleon's Europe is a testament, only dealing with immovable property. Let us now look at another set of opposites, this time involving the ownership of land and property. The natural state and condition of the ownership of property by people who are married or who live together as partners in the British Isles and beyond in the English-speaking world is known as joint tenancy. The word tenancy has rolled down through the years from that time when, not that long ago, when virtually all of the land in the country was owned by a few landowning families as freeholders. Anyone wishing to build a house on the land required a deed of agreement or lease, which was usually for 999 years, requiring an annual payment of ground rent as leaseholders. Ground rentals were originally a significant sum, but in most parts of the country, with the exception of London, they have reduced in value with inflation to a peppercorn and are often never paid at all. The owner of any property, therefore, built on land, was in fact a tenant of the landowner, i.e. the freeholder, usually under the terms of a 999-year ground lease. As a consequence, ownership of the house built upon land that was the subject of a ground lease was known as ownership by joint tenancy. Joint tenancy is a concept that is part of common law. It means that a property owned in joint tenancy is not owned by either party insofar as neither can sell their half or their share of the property. The entire property is owned jointly, but passes into the ownership of the survivor when one of the joint tenants dies. Because of the nature of joint tenancy, this does not involve any deed or even action of transfer of the property, because neither owns the property to pass to the other. What happens is simply that with the death of one of the parties, the other party remains as now the sole owner. It is a concept that is very hard to explain to people living in EU countries, where all property is owned and can only be owned in normal circumstances on what we call a tenancy in common basis. Tenancy in common means that each party owns their half or share, if there were three, of the property in common with the other owners. There are thousands and thousands of English-speaking people from the British Isles, who have owned property in Europe and have died never realising this situation, that each owned their own halves. Property that is owned on a in common basis does not pass to the survivor, whether in the British Isles or the Napoleonic Code world, but it is an asset that is distributed by a testament, if made, or the rules of intestacy, if not. Because they do not understand the situation, hundreds of thousands of English-speaking people who have owned in Europe have written wills passing their interest in the property to their spouse in the traditional English way. Then, on second death, the spouse generally passes the property to the children. The last one out switches out the light, as they commonly say. French and Spanish lawyers listen in bemusement to these instructions, which probably has a lot to do with the expression that only dogs and Englishmen go out in the midday sun, because whilst in the English world there is no tax upon assets passing between husband and wife, in France and Spain, etc., there is. Whilst in the English world there is a substantial nil band or threshold under which inheritance tax is not paid when assets or money are passed to people other than the spouse. In the European world, there is generally only a very small amount by way of tax-free band, typically €8,000 or something. Therefore, for a man to give his property to his wife, or vice versa, involves that survivor inevitably and unnecessarily paying succession tax of up to 27%. And then, on second death, which might only be a month or a few years later, the beneficiaries have to pay the tax again. This time on the whole house, including paying tax for a second time, called a ricochet, upon that half which had belonged to the first to die. English-speaking people routinely pay double tax on properties they own in Europe. And properties owned in Europe by people from the British Isles routinely have to be sold in order to meet that tax payment. That tax is not paid by the giver, as in the English-speaking world, but it's another opposite. It is paid by the receiver in the Napoleonic world. So, there we have covered two important opposites. The third and final opposite that you need to be aware of when dealing in EU or European matters is the concept of public documents and private documents. There is such a thing as a notary in the United Kingdom and the Republic of Ireland. In the United Kingdom, notaries work for the Archbishop of Canterbury because their role involves people swearing on oath that matters are true, which is done on the Bible generally, historically. Whereas, throughout the whole of Europe and beyond, every document of any value is inevitably notarized. That is not to say they have to be notarized. It is possible to write private agreements. It's possible to write a private will. It's possible to come to an agreement privately using an unnotarized document. But it is virtually never done with anything of moment. No European would enter into any kind of serious agreement, such as a loan or buying a car, let alone buying a house, without the documents involved being notarized. Often, even the most minor item becomes delayed because it's felt necessary, imperative, that it is put before the notary. We've described the process of notarization above. The notary is a civil servant, pretty much, a self-employed civil servant, not, as is often thought, some sort of lesser judge or a court official, and a notary effectively, apart from working for himself, works for the tax office. His or her tasks are very simple, which are to be certain that the person appearing before him or her are who they say they are, which calls for people to bring in substantial evidence of identification, and to ensure that the parties seemingly understand the document they are signing, though a notary is not concerned with the legal validity of the documents as such, which in the case of English-speaking people conducting business in the EU means that usually there has to be a translator present who can confirm that those people have read and understood a translation and know what they're doing. As has been said, documents to be notarized can be created by a lawyer and given to the notary so that people can go down and sign in front of him or she, or equally can be created by the notary staff in conversation perhaps with a lawyer or simply directly in conversation with the clients. There's no necessity whatever to use a lawyer in most things in Spain, including buying and selling houses. It's a wise thing to do, but there's no necessity, which has led to a far less robust and organised structure of lawyers, as we call solicitors, in Europe than there is in the UK. In the UK, solicitors have the franchise for most aspects of court work, and only they can process matters through court, which is not the case at all in the EU countries under the Napoleonic Code. What notarization actually does is to make a private document, a private agreement, into a public document, where it can always be identified, found, and seen by people who are authorised to do that, whereas unnotarised wills or agreements are simply private documents. Should the matter ever come to court, then a public document will always win over a private document, and a notarised document is all but infallible in any court situation. Consequently, all bank lending, mortgage lending, purchase of cars, most financial transactions are required to be notified, are required to be notarised. This is completely the opposite of the UK system, where any document under common law simply has to be signed, and in most cases not even witnessed to have legal standing. The will is an exception, however, that in England and Wales it must, as you know, be signed in front of two witnesses who are each in front of each other when the testator and they sign, and who must be focusing their attention upon the testator with the duty to ensure that he or she is not under any sort of duress or under the influence of any substances, and equally upon each other. If a last will and testament is signed and witnessed, that process is called attested, in that way, then its validity is in fact a fact in law, unless someone can prove something to the contrary, i.e. that the witness was that a witness or the testator was under some influence. But there is no notarization, no official process beyond that process. So there are just 3 out of hundreds of core differences in the way that Europeans conduct their life by comparison with those from the British Isles. 5 if you include driving on the other side of the road and putting dots and commas the other way round when you put numbers on paper. The problem for English-speaking people is that when they step off the aeroplane, their new French, Portuguese, Spanish colleagues will be wearing the same clothes, driving the same cars, eating similar if not the same food, and inevitably will speak English. This air of familiarity that everything is the same disguises that only a fraction beneath the surface, almost everything, is upside down, the opposite to the way we understand it, and that leads to a lot of heartache. With all that said, the end objective of this lesson is to provide you with the full and exact knowledge as regards people from the British Isles who do not live in the EU country where they own property. Inevitably, those will be people living and working or retired down the road from your office or house who happen to own a holiday home in an EU country, or who have made that investment into a tourist property in an EU country, or who have purchased a house in the sun, perhaps intending to retire to, whilst at the present time still living in the UK. Some become known as swallows because they go to Europe during certain months and live in their house or apartment through the worst of the English winter, and then return to the green and pleasant land of England for its summer. They nevertheless habitually live in the British Isles, even though they might spend as much as half of the year in their European apartment. The key fact as regards this Group A people is that there is, since Brussels IV, a brick wall that is only crossed if someone moves to the country where they have property and turns it into their habitual residence, leaving behind almost no strands left in their homeland to return easily to. Whenever an English-speaking person moves, for example, to Spain, either to work or live out their retirement and die, thus making that country their habitual home for the time being, if not forever, then they step out of this Group A, they cross the wall, and they join one of Groups B and C. For as long as people are in Group A, which includes those who have lived in the EU and still own property in the EU, but now live habitually back in the British Isles, then here is their position from this point in time. Following Brussels 4, they are still able to make a local will, i.e. a will in Spain, covering simply their property in Spain. But that will must only apply to the property in Spain, and 2, must be a true Spanish will, meaning in the case of Spain that at least 2/3 of the property must go to the children, their blood children or adopted children, and 1/3 can be gifted elsewhere. The will in Spain cannot be written under Brussels 4, i.e. a Spanish will following their national culture. The will in Spain cannot be written under Brussels 4 because they don't live there. If people are comfortable with that situation as regards their property in Spain, which of course can be dealt with quite differently than their property in the British Isles, then through the WA you can write a Spanish will for them. You actually write it in English, more or less as you would do an English will, and it is processed into side-by-side Spanish and English in a manner that is lawful in Spain, and then only requires to be notarized. So you can do that from their living room. That will, once processed, will be in the two languages side by side. Its content would make it absolutely clear that it did not deal with any assets outside of the local EU country, i.e. Spain. Whilst there are some severe disadvantages in writing a local will, there is one single potential advantage, being that probate relating to the property in Spain would be easier and probably less expensive, though there are costs, based upon a Spanish testament than the alternative, which is to obtain a grant of probate in the British Isles upon a British Isles will, which then has to be taken to Spain in a certain format and presented at the notary office. The most logical course of action in the wake of Brussels 4, however, which is far less likely to lead to conflict or problems, is for the British Isles citizen to tear up all previous wills, rescind them, and write a new British Isles will, UK, ROI, Isle of Man, Scotland, in parallel, meaning that their will is split into two parts, meaning they have one single British Isles will of whatever country is appropriate, split into two, with one will covering their, in this case, Spanish property, and the other covering their UK or ROI property or assets. Those two parts must fit like a glove or jigsaw pieces with each other and not overlap. There must be nothing relating to the UK, for example, in the will covering the EU country, and nothing in the EU will covering assets situated in the UK. It is probably more appropriate that all movable assets, even in both countries, should be disposed of through the UK will. Remember what we have been talking about as regards testaments in Europe covering only property. They don't expect to find the jewellery or the paintings in a testament. There is consideration to be given to such things as cars, which cannot so easily be removed from the EU country, but could be converted back into cash, falling under the British Isles will, and businesses and such other items which we deal with in a different lesson that drills down into each country and each situation. As regards the EU side of the equation, the following are crucial. 1. The will must be written in the simplest possible English terminology, and absolutely not making use, as solicitors so love to do, and to our eyes, unfortunately, many Willwriters follow suit of words that are not commonplace English. Legalese. Every will should be capable of being understood by the person that writes it, and nowhere does this apply more than in a will that, at least in part, is destined to be translated into Spanish. The will should be as short as possible, and anything that can be omitted from it and included in the British Isles parallel will should be. That's point 2. Point 3. All people referred to in the will should be identified by their relationship to the testator. Even if it is obvious to you and I that he is not her husband, and that John Smith is the son of Mary Smith, and not her brother or her husband, that is not going to be the slightest bit obvious to a European, particularly a Spaniard, who have an entirely different naming protocol in their culture. When people in some EU countries get married, they retain their own names: Spain, Portugal, France. There is no such thing as the woman taking the man's name, and children of the marriage take one name from each of their parents in Spain, thus and Portugal, thus creating an entirely new double-barrel surname. And so in a Spanish family, the husband will have 2 surnames, the wife will have 2 completely different surnames as well, and their children will have a surname made up of one half of each of their parents' surnames. And Portugal is the same, though it's around the other way. And the law of France actually requires everyone to keep their birth name throughout their entire life. It's therefore key that each John Smith, Mary Smith, etc., named in a will is identified by their relationship to the testator. And in the clauses the WA provides, it can be seen for those listeners who use WA software that there is an option in the opening paragraph for the testator to state that she is Mary Smith, the daughter of John and Jane Jones, which is another Napoleonic code tradition in line with their naming protocol, thus linking the person to in the document to their parents. That is not necessary. It is simply what the Spanish eyes expect to see. All of the information that has gone before in this lesson should leave a situation where in 80 to 100% of the cases where you are talking to a client who lives in the British Isles with property abroad, they will scrap their existing EU country will, whether it's Spanglish or otherwise, along with their existing British Isles will, UK or ROI will, and you will write a pair of parallel wills separating the assets in Spain from those in the UK. Exactly how this will is written and the wording and clauses it contains is a subject of a further lesson, a couple of lessons down the track. The key points for consideration are: 1. Is the client going to press on and then seek to eliminate, well, not seek to actually eliminate succession taxes by instructing you to set up a roost structure for him? In which case, what will be needed to take into consideration as regards the ultimate purpose of the will, which, once those arrangements are completed, becomes a drip tray beneath the roost, which is a remote overseas ownership structure, about which we'll talk more in a later lesson. Your will, after the structure is in place in 3 or 4 months' time, will then be a drip tray only dealing with such items that have not gone into the roost. Secondly, there will need to be a conversation about the chattels that are in the EU property, whether or not the property has been filled from the local IKEA with contents that would simply remain in it for ongoing use by children or grandchildren, or does the property contain valuable personal possessions brought over from England which need to be referred to and dealt with within the British Isles will. You will have to consider the simplicity of the language of the clauses in the Spanish side of this arrangement if you're writing wills using your own or proprietary will writing software. The Willwriters Association has dumbed down all of the clauses it recommends, removing words and expressions that are not easily translatable or possible to translate. Some words just do not translate into Spanish, and thus reducing the often windy nature of clauses formed by UK lawyers to something simpler that creates a shorter and simpler translation. You will need to explain and obtain a conclusion to the proposition on the first death that the property is not passed in the English tradition to the partner or spouse, but goes straight to the children to avoid double taxation. But you will of course have to warn of the nightmares of the tax situation and the potential problems arising out of divorce after someone has been given dad's share of the property or bankruptcy. The purpose of the wills you write is, of course, to deal with the ultimate death of one, and then both, of the owners of the property in the EU. If the point has been taken on board by you regarding double ricochet taxation, and you've been able to pass it on to your clients, then the beneficiaries of the EU property parallel will be different from the UK or British Isles side of the parallel wills. On the UK side, invariably, whoever dies first will pass everything to their spouse or partner, and only thereafter to their children or whoever, whereas on the EU side, your clients hopefully will have taken your advice to pass the property straight to the children. That, however, that conversation resurrects the problem that leads to the British Isles practice of not wishing the children to control property assets, given the potential for there to be marriages, divorces and irresponsibility somewhere in their lifestyles. The solution to that problem in an EU country is the same in the UK, which is to give lifetime use to the survivor, the usufructo, in Spain. The expression lifetime use tends not to be used in the EU, where the Latin usufruct, which is an English word as well, use of the fruits, is only ever used. Consequently, the Spanish side of the parallel wills is likely to vary significantly from the English side of the parallel wills in this regard, there being a gift to the children or grandchildren of the property asset with lifetime use given to the spouse or partner. Because of this advised variation from the British Isles cultural norm, there is an entire lesson on lifetime use, the usufructa, which is very heavily used on the continents for the reasons explained. Lifetime use can, for example, be extended for 2 generations, so it can be given to a partner and then on to a child of a relationship, perhaps. Following the death of the individual, nothing initially takes place in the EU country. The 2 parallel wills in respect of the deceased testator are taken to the British Isles Registry of Births, Marriages and Deaths to be processed for probate in exactly the same way as if they were one single will. The clauses of both wills will reflect each other and make it absolutely clear that the 2 wills are designed to live alongside each other and don't conflict in any way, and will have been written as a consequence of your training without any cross-contamination. The court will simply accept the 2 wills into the probate process, no differently than if they were one, other than that at the end of the process of probate there will be 2 letters of probate or grants of probate instructing the executors and trustees in their duties in 2 different directions. And the British Isles letter of probate will be used by the executors in the normal way to call in the assets and the bank accounts, etc., whilst the grant of probate in respect of the EU parallel will must now be prepared to be taken to that country. Now this calls for a bundle of documents, being the original grant of probate, and the original of the Spanish parallel will to be processed via the Foreign Office to be apostilled. Apostille is a stamp attached to a document by the Foreign Office confirming that it is valid and lawful in the United Kingdom or the Republic or Ireland or Canada or America. It's a worldwide process. At one time it was necessary to visit the Foreign Office. Now they offer a fast turnaround postal service. It's a relatively straightforward process, though one that we will need to assist you to be familiar with when those times arise. The process of an apostille then attaches a certificate from the British government confirming that the documents that have been apostilled are lawful. When documents have that certificate of apostille, then the authorities and the notaries in the EU just take the document at face value as being true and legitimate. They don't query it or question it. If it has an apostille on it, that's it. The apostille document will need to go to the country for use by the beneficiaries at the notary. They take the documents to the notary and they say, please may I have my half of the property or whatever. So, the process is that the beneficiary will visit the notary, probably with a lawyer, with all of the relevant details of the property, and cars and bank accounts, anything or whatever to be transferred by the testament is, with a request that those assets are transferred to them as beneficiary, as set out in the will and grant of probate from England, Scotland, Wales, wherever. Now, the notary will require either parts or sometimes all. It depends on how the notary likes to operate, how modern they are, if you like, to be translated. There are authorised translators attached to notaries in every country, and the translator will either extract parts that the notary wants to know about following a conversation, or will just translate the whole lot. It's because of the need for these documents to be substantially translated that the EU side of the will equation is kept to an absolute minimum and kept totally translatable. This is the point in time when a 5-page English solicitor/barrister originated clause involving antique English language and expressions that are only conducted between lawyers and involving lengthy, windy clauses relating to English law, such as trust and trustee clauses, whereas the Napoleonic countries don't have or recognise trusts or trustees, nor even executors, become an absolute nightmare and very expensive, and lead to the abject almost refusal, that the suggestion by local lawyers and people who know anything about anything to say, for goodness sake, don't bring an English will to Spain. That is not true if the English will has been properly prepared with its end use in mind. Every will written as the EU side of parallel wills must be shrunk and reduced to the simplest possible language to achieve what is probably a very simple aim to transfer: a bank account and its contents in Spain, a car and any assets worth mentioning individually where those can fit into a testament, which is a different issue from country to country, the testator's share of land and property, and those are what will be transferred to the beneficiary. There is no need for anything else beyond the minimum words to achieve those things. Every EU country has a time limit by which the beneficiary must notify the authorities of the death and of the succession position, which is usually 6 months, sometimes a little longer. And so the probate process in the British Isles, in Scotland or England, needs to be addressed with some urgency, but it is perfectly possible for the timescales to be achieved. Napoleonic Code EU countries do not have inheritance tax. Inheritance tax is what we have in the UK when the tax is paid by or from the estate of the giver. They have succession tax. Succession tax is when the tax is paid by the person who receives, which is another upside down. Inheritance tax is that situation where the estate of the deceased which involves an executor, which they don't have in Napoleonic countries, who gathers in the estate and pays the tax before the assets are distributed. It is therefore the net asset in the British Isles, after payment of inheritance tax and allowance of the relevant thresholds being taken into account, that is distributed. There is, of course, no tax in the British Isles applying between husband and wife. And so invariably the first to die leaves everything to the survivor, and it's the survivor who distributes the children after the payment of a tax, if applicable. In the Napoleonic Code EU countries, the assets owned by each tenant in common is transferred to the beneficiary by way of the process we've described at the notary office. There is no court process involved, and that is done on the basis of the grant of probate supported by the will. Tax is simply payable by the beneficiary as they receive the bequest. And so they might go to a lawyer and he will check what tax is payable, and they will turn up to the notary with their paperwork asking for their gift and with the money to pay the tax. The taxation payable by a beneficiary generally varies from person to person. If an adult son, and we are here talking about Spain, but the principle applies across the EU, if an adult son, a brother, and a partner or fiancé go together to the notary in Spain, in order each to receive 120,000 euros in assets, then the tax-free band, meaning the amount of that 120,000 that they will not be required to pay tax on, is for the son nearly 16,000. The figures below. For the brother, it is nearly 8,000. But for the partner or fiancé, it is nil. The amount of basic tax payable on the remainder will be 15,606.22, and you'll notice we've written that in English. If we were writing it in Spanish, it would be €15.606, 22. Then the tax will be multiplied as a consequence of the legal relationship between the beneficiary and the testator. So the basic tax is that 15,606.22, which now becomes multiplied. In the case of the son, who is wholly approved by the state as the recipient, the multiplier is a factor of 1, so there's no change. In the case of the brother, who is frowned upon but allowed, the multiplier is a factor of 1.5, so he must pay around 24,000. In the case of the fiancé, where there is no blood or legal relationship, the tax is doubled, so she has to turn up with a bag of £32,000 cash to pay the notary, nowadays done by other means than cash. Then finally, the last hurdle, each must demonstrate their pre-existing net wealth, and that is taken into account. And if one happens to be worth more than 400,000, then the tax is further increased in a similar way. Once again, the son times 1, so no change, the brother times 1.5, and the fiancé times 2, to reflect the level of their existing wealth. And when you consider that a very large number of English-speaking people who own property in the UK own houses worth 225,000 or more, which is 300,000 euros, and you consider the levels of tax payable by those three beneficiaries, it will become very clear to you why the conversation almost inevitably moves on to tax avoidance. Because the fact is that both in the eyes of Spain, and certainly once they understand it, the eyes of your clients, this is unnecessary tax to be paying. Completely unnecessary. Not expected, not wanted. Well, maybe wanted, but not expected and not really wanted. It's unfair. Tax evasion, by the way, is the unlawful practice of non-declaration or any other form of constructive evasion of tax. Tax avoidance is the process of taking reasonable care not to pay more tax than is necessary or due. Each of us has an obligation to exercise tax avoidance. There can be no complaint nor any financial compensation available when someone fails to avoid paying tax they need not pay. In other words, they can't ask for it back, either here or in any part of Europe, and in particular Spain. There is absolutely no need whatsoever for anybody from the British Isles to put themselves into a position as if they were French, Spanish or Portuguese, working, living, retiring, etc., in the country where they've purchased a property, and to pay those national taxes. If people from the UK take the correct advice, which it is open to you to take further training upon in order to be able to give, then all of this tax can be totally lawfully avoided. And so when the beneficiaries walk out of the notary in the EU, their deeds of transfer in Spain, an escritura, or bag of cash, after the payment of tax, your job as the will writer is done. If the exercise has gone smoothly and relatively inexpensively, you will have done your job well. And all of this dedication to learning and understanding these unfamiliar and confusing matters in order to give your client exactly the correct advice and the correct service will have been very worthwhile. It'll give you a very good feel. In the lessons that follow, we're going to look at marketing your services to Group A and what the wills for Group A folk actually contain by way of precedents and clauses. And also we shall move on to Group B and C, who are respectively the people who move to a place in the EU intending to come back, which is Group B, so they went there to work and then will come back, or they went there to have a few years in the sun after retirement but will come back, or Group C, who went there to remain and live out their lives and effectively die there. Before then, please go back through this lesson as often as you need to ingest all of these unfamiliar concepts and processes that it contains. I will see you in the next lesson.